Thank you all for attending this month's 30-minute skills class, FERPA and public records. As a reminder, all of our 30-minute skills classes can be found at nefac.org/30-minute skills. We're joined today by Mike Heaston, an attorney at the Student Press Law Center. Mike is going to explain to us what FERPA is, when it applies, and how to best respond to public record denials that are incorrectly attributed to the law. With that said, Mike, all yours.
All right. Hey, thanks, Justin. Let me just give a quick introduction of who I am so you can understand kind of my interest in FERPA and why it comes up a fair share. As Justin said, I'm an attorney with a group called the Student Press Law Center, who hopefully some of you have heard about before, but we're a nonprofit based in Washington, D.C. I'm actually lucky to be living out here in the other Washington, Washington State. We've been around since 1974, which is a year you'll hear about a little bit more in just a second. But our whole reason for being in business is to provide free legal help and information to high school and college student journalists and their advisors, attorneys that might be working with them. And so we get a lot of questions about FERPA because our the folks that I work with are very often they're covering their schools and they're trying to get access to information about what's happening on their schools. And so unfortunately, FERPA is a common justification that they are confronted with when they're trying to get some of that information. So we have 30 minutes, so we're going to keep this fairly short and sweet and hopefully fairly practical. I think there should be some time at the end for questions if you have any, but we'll start just basically with what the basics are. FERPA it was a law that was actually passed in 1974, same year we were founded, the SPLC, and it was passed to address what were during testimony came out to be some fairly significant abuses when it came to schools working with education records, student school records, and so I mean there's some of the testimony that came out suggested, for example, that if an employer was looking to hire a student, they could actually walk down to the high school and ask to see a copy of Johnny's transcripts before they decided to hire him. There were a lot of that sort. There just wasn't this sort of understanding that we have today that there is an expectation of privacy in those sorts of records. The problem with FERPA, as we will talk about at a fair share of length here, is that it's kind of a good law that's gone bad. And we'll talk about some of the reasons for that and some of the ways you can really kind of push back on some of the excuses that school officials frequently give for using the FERPA excuse. A lot of people don't recognize or don't realize that there are kind of two sides of FERPA. The first side of FERPA, which is actually kind of is a good thing and doesn't really provide create any sort of problems for the folks that I work with, is that FERPA provides a right of access and oversight to one's own education records. So FERPA requires that schools provide students, or if the student's a minor, the student's parents, with a copy of their own education records, their own file. And it also has a process in place for allowing students to correct things that might be wrong in those records. They can ask that omissions or something be corrected. If you're ever interested in finding out, for example, what your third grade teacher thought of you, you can actually send a FERPA request to your school district where you went to school there, and within 45 days approximately, they're supposed to provide a copy of your education records, which is going to include your transcripts, your test scores, teacher comments that they might have made. So kind of fun thing to do. I did that many years ago. I was a joy to teach, apparently. I came up over and over. The part that we're going to spend most of our time on today is the other side of FERPA, which restricts access to other students' education records. And you probably saw on both slides here that education records is in quotes, because really the whole concept of what constitutes an education record under FERPA is kind of where the most of the problems arise. The definition of education records that's listed in FERPA is really so squishy and unworkable. I mean, it's just proven itself to be this unworkable sort of frame for addressing these sorts of issues. And school officials really take advantage of it. So we're going to talk about a few things, places where they've done that. For example, I mean, there have been, lots and lots of cases where schools have claimed that records that I don't think any of us would really consider to be education records, records related to a student's academic life, have been cited as FERPA records. And because they're FERPA records, the school claims that they can't be disclosed. Scores of a high school swimming meet. So, everybody at the swimming meet could see these scores, but for whatever reason, the school officials in this case decided that they were FERPA records. Video of students playing high school football, number of guns brought into Ohio schools over a school year. And these aren't from court cases necessarily. These are just claims that have been made over the years by school officials. The nickname given to a watermelon used as a prop in a fraternity hazing stunt. I mean, just nonsensical things. One thing that's been a problem for me in particular is some schools. In fact, I was actually just working with an advisor, high school advisor in California last night, where this is an issue. So the school has claimed that, a story published or hoping to be published by the student newspaper. It's a student edited newspaper. They're claiming that some of the information in that story, because it involves a student, guess what? Student newspapers cover students, but they're claiming that the student newspaper is itself a FERPA protected education record. I think we'll be able to shoot that down pretty quickly, but you can just kind of see, some of the lengths to which school officials, have gone to really take advantage again of the squishiness in this law, and they have used FERPA as really an excuse to not release records they simply don't want to release. If there's any sort of student name, any sort of student information in a record, they say, hey, FERPA, we're not going to release it. Now, there are a few things that we know for sure that FERPA does not apply to. The first one of these is this exception in FERPA, in the law itself, that says that schools can release what they call directory information. Now, like a lot of things in FERPA, the problem with this is that there is no uniform definition of what constitutes directory information in FERPA itself. There's this wacky system where the Department of Education has allowed schools to create their own lists of what they consider to be directory information. And typically, I mean, where things like, name, a student name, their dates of attendance, whether or not they participated, in any particular extracurriculars or things like that. Sometimes email, sometimes student addresses. Again, it varies a little bit from school to school, but the way that it works is the school publishes its list that says, this is what we're going to be considering directory information at our school. And parents or students, if you object to that, you can let us know that we can't even release directory information. But if we don't hear from you, that's going to be available. So, there is going to be some information that's always that you can just go to the directory information list, and if the school is citing FERPA as an excuse for example, for not telling you if a school attended during a particular period of time, you can just say, look, you've already exempted that information. We also know that records of law enforcement agencies are not subject to FERPA, and that actually came about as a result of a lawsuit that we at the Student Press Law Center filed against the Department of Education back in the early 90s. Again, schools, I don't know, some school lawyer someplace got the idea that, look, we would rather not share information about campus crime that takes place. It's not super good for our image here. And so they started claiming that campus law enforcement records, campus police records, were FERPA protected records and couldn't be released. So if there was a sexual assault on campus, the school police would claim when a student reporter or somebody else went to get information about it. Sorry, we'd love to help you, but it's FERPA protected. We cannot, we can't tell you whether a student was charged with sexual assault last night. So we sued the Department of Education, and there was an exemption that was put into place that made clear that the records of law enforcement agencies are not education records. The outcomes of disciplinary cases where a college student is found liable for a violent crime or a sex crime. Most schools, all schools, I think, have some sort of, at least at the post-secondary level, have what we call campus courts, a campus judicial system that was started many years ago, basically to handle academic offenses, plagiarism, cheating, that sort of thing. But these things have morphed into a place where they are handling sexual assault cases. They're handling very serious criminal cases that would normally be handled within the normal judicial system, but schools are taking that on. I actually had, I think, Julia Furukawa, who is a student or was a student at Western Washington University out here in my area, is actually suing their school because they are refusing to provide the outcomes of disciplinary cases for students that have been found liable. There was a finding of responsibility or guilt for violent crimes. That is actually also an exemption that's listed in FERPA, but that schools are doing whatever they can to avoid. Records of deceased college students, dead students have no privacy rights. We also know that peer grading. So, you remember back in grade school where you did a spelling test and the teacher says, go ahead and hand your paper to your next door neighbor and we'll all grade the papers together. A parent challenged that practice, and the case actually worked its way all the way to the Supreme Court in 2002. The Supreme Court said that no, peer grading does not violate FERPA, that those papers, when you hand them to another student for grading, don't transform themselves into an education record, at least not until the teacher actually records those grades in their yearbook. A lot of good things actually came out of the Falwell decision because they made clear that not every record is an education record, even though it involves students. That there has to be the purpose of FERPA was to protect true education records that are maintained typically like at a central location by the school. And then there are some, schools have to show a few things before they can start claiming this FERPA excuse. There are, because the law really is so murky, so squishy, you really can find lawsuits and judicial, cases that say almost anything. And we're not going to go through a lot of these here, but lawsuit settlements aren't covered according to one case when they involve students. Emails among employees that have that refer to students aren't covered by FERPA. Parking tickets issued by a college are not FERPA records, a court said. And again, in order to get to that place, the school had to make those claims that those records were protected. On the other hand, results of an internal investigation into a botched sexual assault case, are subject to FERPA protection, as are coaches' emails, including to and from a football booster, not a student, but a booster, are covered by FERPA. Again, all over the place. And so it's really difficult sometimes getting a clear read on what FERPA does and does not cover. One thing that is particularly helpful, though, and it's taken a while, I think, for the Department of Education to kind of get in the ball game with this, but we have had some helpful rulings that have tried to, that have come out of the DOE. So the Department of Education is the federal agency that's responsible for enforcing FERPA. In fact, there's a special FERPA compliance office, the Office of Family Policy Compliance. It's called that issues opinions interpreting FERPA. But one of the things they've made clear is that FERPA applies to the disclosure of tangible records only. And information that's derived from those tangible records. We often have school officials saying we cannot talk about a particular case. We cannot talk because it involves students. But again, FERPA is a records-based law. If there is no tangible record that includes the information, and if the information is not coming from that tangible record, you can talk about students. You can actually, when you call and ask for comment and they say, I can't comment, it's FERPA, if there's no record that they could point to that includes the information you're asking, there is no FERPA problem. So a few different pointers here before we kind of start with some questions and things if you guys have it. But one of the things that you can do in pushing back, and I really do encourage you, when you get these standard, and at many schools are just a standard, I'm sure it's on in a form letter that comes back, can't provide that information, it's covered by FERPA. It's really important that we all push back on those sorts of claims. One of the ways you can do that is, expose the hypocrisy. So if a record truly is covered by FERPA, as I said in the first part, they have to provide that record to the student about whom the record discusses. So call them out if they're claiming that that some particular record is FERPA protected, and about the student about whom the record or the information concerns, have the student make a request, work with the student to see if they would make a request to obtain their own record. There has to be a record. If there's no record, there's no FERPA violation. So make them produce that record and provide it to the student. They have the opportunity to correct the things that are not correct in that record. So, they have to provide that information, and oftentimes they're going to realize there is no record, there's no FERPA problem. The other thing is that FERPA is, as we are talking about here, FERPA is regularly used to deny FOIA requests, open records requests. The problem with that is that the downside for releasing a record that truly is covered by FERPA is basically it's the nuclear option. There is only one penalty for violation of FERPA, and that is the total disqualification, the elimination of all federal education funding. So we're talking about grants and things like that. We're also talking about the eligibility for student loans, student financial aid, things like that. So it really it's a huge sort of penalty that would be invoked. Basically, probably eliminating the institution, their ability to continue conducting business. So that's the option. So there's no real the downside for releasing a record that is subject to FERPA is huge. Schools will claim. On the other hand, there really is no upside or there is no practical penalty for erring on the side of non-disclosure. A couple of different things, though. There has been a ruling that there is no private cause of action under FERPA. So if a student or a student's parent claims that a school is violating FERPA, they don't have a right under that statute to actually sue the school itself. So, the risks to a school are actually quite minimal. There's also another Supreme Court case in 2002 involving Gonzaga University, where the Supreme Court held that there was also no what we call a Section 1983 cause of action under FERPA. So, for the lawyers in the audience, you'll know what that is. But there really is no good way for the students whose privacy has been violated, or who claims their privacy has been violated, to actually go to court to get some relief that way. They can file a complaint with the Department of Education, and they can launch an investigation and all that sort of thing. The other part of FERPA that really does shield schools from liability, which kind of ought to put an end to this, the mass FERPA denials, is that in order to be found responsible, in order to be found guilty of violating FERPA, the violations have to be part of an institution's policy or practice. So there has to be an established policy or practice of regularly providing student education records to people that aren't entitled to get that information. A single mistake does not trigger FERPA's death penalty. Because the penalties are so draconian, we are not aware, certainly, and I think we probably would be, no school has ever been found non-compliant and penalized during FERPA's 47-year history. There just hasn't been, there's never been this invocation of this nuclear option. But again, FERPA is cited over and over and over by virtually every school, when any sort of record involves a student. The other thing is, there have been a number of court cases out there that have questioned FERPA's constitutionality and just the legality in general. One of the things that's a problem is that you have this conflict oftentimes between an open records law at the state level and FERPA, where, the open records law seems to very clearly require the disclosure of the records that you might be seeking. But because there is this federal law in place, it kind of nullifies the access provisions in the open records law. And so, yeah, there have been a few court cases, a couple of judges that have started to say, we need to really look at the constitutionality of this law. So I will say, as I was getting ready for the presentation tomorrow or today, in between some of the things I was doing for this, I actually had to do some pre-publication review of a story where I actually, in reading the story, the story was about a student that had been admitted to a school, even though he was in the middle of a rape trial, basically. And so student reporters had gotten wind of this. They found out the school really hadn't, done its homework and hadn't done the proper screening. And so they were asking the school officials for comment, and they said, no, we can't comment. This is a FERPA related matter. And in that story, there was actually a quote by Frank Lamani, who was the former ED here at the Student Press Law Center. And really, Frank has taken FERPA on as kind of his personal project. So if any of you guys are ever interested in doing a story specifically on FERPA, he is the expert. He's now the director of the Breckner Center down at the University of Florida. But he reminded me, as I was reading the story, there's a quote in there from Frank Lamani. So I said, I probably need to be in this presentation, where he just says, it really is. It's a very narrow statute, and it's very hard to violate, again, unless there is a policy or practice of releasing student records, and unless the information that you're trying to obtain is actually in a particular record, there is no FERPA violation. FERPA is very narrow, and we really need to push back against schools that are trying to create this enormous sort of exception. All right, I think that's all I have right now. I'm happy to entertain questions. And
thank you, Mike. That was really helpful. As we wrap up here, I have one question for you. Just looking for some practical advice for when someone makes a records request and they're immediately told, nope, can't give you that information, FERPA, other than pointing them to this very presentation and saying, no, that's incorrect, FERPA doesn't apply. What kind of advice or guidance would you give that person outside of using, their public records appeals process? What advice would you give them to actually get those records and set the school straight?
So I did mention one of those things, if you know the student about whom the records, are supposedly concerning, and if there is any ability to work with that student. I mean, a lot of my reporters are, they're trying to get information from the school. Perhaps the school has botched a particular, like one of these campus crime or campus court sort of proceedings, and they're trying to expose that information. So you can work with the student to see if they would request their own records, or if you are making a request, get some sort of release from them that releases the school from having to comply with FERPA. Consent is supposed to take care of any sort of FERPA objection. So if the student consents to the release of their records, you ought to, the school ought to provide that. But beyond that, it really is. I mean, it's this very one-sided thing, where schools are simply, they're just going to say FERPA because they think they can, and it's up to us to go through that administrative appeals process that exists in the various states, or sometimes even to go to court, which is just this huge barrier that very few of us exercise on a regular basis or have the ability to do so. So yeah, it's the thing that needs to happen is the law needs to be changed, and that has, I mean, there have been calls over the years for a reform of FERPA. In fact, even I think as recently as like 2018, President Trump, as part of his sort of looking at how campus disciplinary actions are conducted in schools. They said that their administration was going to look at FERPA. Nothing really came about that, but there continue to be, fairly regular calls for some sort of changes for modifications to FERPA. So that it goes back, like I said, it was a good law. I mean, it really did address a pretty clear problem, but it just does so in a way that in many ways creates more problems than it does fix.
Got a couple more questions here. Age restrictions around FERPA. Does FERPA cover all educational records regardless of the age of the student, or are there some openings to get certain records depending on the age?
Nope, it covers students at school. So yeah, so if the student is a minor, the privacy rights or the student records can be requested by a parent. Once the student is of age, those rights belong to the student themselves. But that's kind of the only age things in FERPA.
All right. So just a quick follow up to that. High school students that might be of adult age, 18 and over, there's no distinction made there as far as their age is concerned. FERPA applies the same way.
FERPA applies the same way, but they would be the ones that would be in the position to request their own records as opposed to the parents.
Got it. And then last question here before we wrap up. You mentioned at the beginning of your presentation this great idea of actually going back and requesting your own records. Yeah. Is there any time limit involved there? Are those records supposed to be on file in perpetuity? How far back can we go with a request?
Yeah, no, I think we're all eligible to go back and request our FERPA records, even though some of us it's been a long time since we've been in school. Records, typically they are held at the district level, for a certain period of time, and after that, they're often archived someplace. So there may be, there may be a delay depending on, if you have graduated a long time ago. But 45 days is basically what the time frame that the statute provides for.
Great. Mike, thank you so much. This is all very, very helpful. And I want to thank everyone who attended this 30-minute skills class. If you found this lesson helpful, please let others know. We have many classes like this one, all available at nefac.org. So please check them out and tell others about this great resource. Also consider supporting our work by making a donation at nefac.org. Or Mike, where can people go if they want to support SPLC?
SPLC.org.
Easy enough. Great. Well, thank you again. And thank you all. We'll see you next month for another 30-minute skills class.